Hi, I'm Emily, founder of Apex Law School Prep and Support. Just want to take a few minutes to briefly go over with you California, February 2023 bar exam question 1. First thing you might notice about this essay is it's on the longer side. It's a little bit over a page. If that scares you, you can try to reframe as the more that they've given you in this fact pattern, potentially that means there are more issues in there that you can find in IRAC. Every issue that you IRAC, potentially more points, and or they're giving you potentially more facts in this fact pattern. And the more facts that you can figure out how to use in your fact pattern, if you can find a home for them in your response, either they help trigger a new issue for you to IRAC, or you use them as support for an element or a factor when you're applying your rules, or maybe they help you come up with counter arguments, all of that translates to points. Okay, let's jump into the calls of the question. Number 1, did the court properly deny Duratire's motion to dismiss? Discuss. Hard to know where that's going. Motion to dismiss could be in Civ Pro, or they could be getting at the underlying elements of whatever claim that the party's moving to dismiss, so we just don't know yet. Number 2, did the court properly grant Duratire's motion, A, to compel production of the statement from Wynn? Discuss, and B, to compel a physical examination of Pam? Discuss. So compelling production, compelling a physical exam, these are motions to compel. This is discovery land, Civ Pro. And then 3, did the court properly order Duratires to produce its scientific report? Discuss. So production of a report, again, looks like more discovery stuff. Okay, let's jump in. Duratires manufactures and installs specially coated tires. Okay, manufacturer and installer, don't know what to do with that yet. Duratires advertised that a scientific report declared that its tires will not go flat for the first 7,000 miles of use if driven properly. So to the extent that Duratires is advertising, based on this report, that your tires will not go flat for the first 7,000 miles if you drive them properly, that's an express warranty. Duratire's scientific report was created at the direction of its legal counsel and contained research on flat tire incidents involving Duratires. So this at the direction of legal counsel hopefully sets off some bells for you about work product. So anytime that you are asked about discovery, whether something is discoverable, whether it's should be protected or the party should be compelled to produce it, you want to think potentially about a few issues. One is the information that they're seeking within the permissible scope of discovery? And that means, is it relevant? Is it proportional? And it must not be work product or privileged. And so that work product piece, that's where this goes. So you want to be thinking about that. The other things that you would think of after you decide whether something's in the scope of discovery, you want to be thinking about, are they using the proper discovery tool to seek that information? And then if it's properly within the scope and they're seeking it properly, is the other party not cooperating, and what can they do? Can they move to compel, and do they use the right process for that? So we'll see if we have to get into all that. Okay, paragraph 2. Pam purchased 4 new tires from Duratires and had them installed by Maurice, a mechanic. Okay, so Pam, P, presumably plaintiff, Duratires, presumably defendant, had them installed by Maurice, a mechanic. Who is Maurice? So he installed them. The first sentence of the essay says Duratires manufactures and installs. So maybe Maurice is an employee of Duratires, working for them doing installation, or independent contractor. Maybe he's just some unaffiliated random mechanic. It seems very vague. We'll see if they give us any more information for that. Pam drove 100 miles and one tire went flat. Okay, so it'd be a breach of that express warranty, causing Pam to swerve and crash into another car. Pam was not physically injured in the accident. Okay, Pam was not physically injured. That is interesting to me because of that question 2B, that Dura is moving to compel a physical exam of Pam. Now, in California, if you are bringing a personal injury case, then the other side automatically gets to take a physical exam of you. If you're in federal court, and we don't know where we are yet, if you're in federal court, you have to get a court order for that physical exam. And you can only do that if you show that the person's physical health is in controversy and you show good cause. So here, Pam's not physically injured. It seems like that standard might be hard to meet. Then we have Pam gathered a written statement from the other driver, Wynn. So that's our statement for 2A, to compel production of the statement from Wynn, who suffered minor injury. And Wynn's statement was favorable to Pam's case. Okay, so a couple of things I think about there. We talked about already, when you think of discovery, that first question that I ask is this within the permissible scope of discovery, meaning relevant, proportional, and not privileged or work product? That relevant piece, in federal court, we're talking about relevant to a claim or defense. That is broader than admissible. So the reason I bring that up here is because I see that it's a written statement from another driver. The first thing that pops out to me there is hearsay. But they haven't asked us specifically about hearsay. So when I'm not going to write about that, but what I'm thinking about is when I talk about whether it's relevant for discovery, I'm going to say, even if it turns out to be inadmissible hearsay, that does not preclude it from being relevant for purpose of discovery, meaning it can still be discoverable even if it's ultimately not going to be admissible at trial. Okay, then we move on. Pam filed and properly served a complaint in federal court. Okay, so throw all those California rules away, against Dura Tire for breach of warranty and negligent installation and manufacture of the tires. Okay, so breach of warranty and negligence, these are state law claims. It's federal court. Tells me its subject matter jurisdiction is based on diversity. The federal court had proper jurisdiction over Pam's complaint. Okay, so it's a non-issue. It's diversity jurisdiction. Pam alleged that she suffered property damage and emotional distress as a result of the accident. So again, I'm thinking when I see that property and emotional distress, I'm thinking back to that 2B to compel a physical exam. So federal court, so we know we're going to need a court order. We're going to need to show that the physical health of Pam is actually in controversy and that there is good cause for this exam. So on its face, she's not physically injured. She's suing for property damage and emotional distress. Nothing physical. Seems like a physical exam would be improper. However, they seem intentionally vague with this emotional distress word. I know that in order to recover damages for emotional harm, you have to be in one of two situations. One, if you're claiming ordinary negligence, you have to first show physical harm, and those emotional harm damages are parasitic to, meaning they piggyback onto the physical. Once you show the physical, then you can ask for the emotional. But here, she's not claiming physical. It says she was not physically injured, so that's not going to be an option for us. So the other way to recover for emotional distress is IIED or NIED. Now here, since it's a negligence theory, I'm thinking NIED, negligent infliction of emotional distress. There's three flavors of that. The one that seems like it would be applicable here is going to be that near-miss zone of danger, because she was in a car accident. She was in the zone where she could have been physically harmed, but she wasn't. And for that one, we need to show in most states a physical manifestation of her emotional distress. And so if we're thinking about it that way, if this is an NIED claim on a near miss theory and she needs to show that physical manifestation, now I'm thinking her physical health is in controversy. If she's going to claim she has that physical manifestation and Dura is going to claim she doesn't, and then there would be good cause for the exam if that's in dispute. So if I think about it in that way, then I think, okay, even though she's not actually physically injured and not claiming physical injury, maybe Dura can get that motion to compel the physical exam if it's that near miss NIED theory. Okay, we'll see if they give us any more facts, but that's what jumps out to me there. Next paragraph. Dura Tires filed the motion to dismiss for failure to join Maurice, that was our mechanic, as a defendant. The court denied Dura Tires' motion, and then Dura Tires filed and properly served an answer to Pam's complaint. Okay. So motion to dismiss for failure to join Maurice, that's failure to join an indispensable party. It's Rule 19. You don't need to know the numbers, but if that rings any bells for you, because we're in federal court. So when we think about failure to join an indispensable party, I think about it in three steps. One, we're going to ask if Maurice, this absentee, is a necessary party, meaning if we were to proceed without him, would he be harmed, the absentee, or would plaintiff be harmed, meaning the court wouldn't be able to accord her complete relief without Maurice being joined? Or third option, would defendant be harmed? Would Dura be subject to multiple or inconsistent obligations if we don't join Maurice? Once I walk through that, is Maurice a necessary party? If I decide that he is a necessary party because we're going to have harm to either him, P, or D, my next question would be to ask if joinder is feasible. That means, is there personal jurisdiction, subject matter jurisdiction, and venue over Maurice? And if there is, we're going to join him. If there's not, we're saying, oh, he's necessary, joinder's not feasible. Our third step is he so vital to this lawsuit that we cannot proceed without him? And if that's the case, we're going to label him indispensable, and the court will dismiss for failure to join an indispensable party. And the court has some discretion there. There's some factors that we'd use to decide that. So I'm going to keep reading and see if we have any more facts about Maurice before I analyze that, but that's where I'm anticipating going. And then I see that, Dura Tires filed and properly served the answer. So, moving to dismiss for failure to join an indispensable party, that's not a waivable challenge. So Dura could have done that at any point. It looks like they did that initially as their first response, so not an issue anyway. Okay, next paragraph. Pam served her initial disclosures on Dura Tires, but did not produce Wynn's statement. So initial disclosures, these are these self-initiated mandatory disclosures in federal court. There's some things that you have to automatically turn over to the other side. and includes the names of potential witnesses and their contact info, subject matter about whatever information that they have relating to the case. That wouldn't require us to turn over Wynn's statement here. That would just be Wynn's name and contact info. Second category that you have for those mandatory initial disclosures, documents that support, it's also tangible evidence and ESI, that support a claim or defense. So here I see it's a written statement from Wynn. I'm thinking that could fall under that second category of initial disclosures of documents that would support her claim because they told us it's favorable to Pam's case. So I'm thinking, yeah, okay, this should have been produced in the initial disclosures. And you don't have to produce that if it's only going to be used for impeachment. But here, if it's favorable to her case, she's probably going to try to use it substantively. And then we have Dura tires filed and served. Oh, the other two categories of those mandatory disclosures are related to insurance and then damages calculations. Those don't seem to be at issue here. It really seems to be more that second category. So then Dura tires filed and served motions to compel Pam to produce Wynn's statement and for Pam to submit to a physical exam, and the court granted both motions. So I think there are grounds to grant or to make both of these properly discoverable, right? I think for that statement, I think it can fall in that second category of documents that support her claim. And then for Pam to submit to a physical exam, I think if we're looking at it as that near miss NIED theory that requires that physical manifestation, make that argument there that her physical health is in controversy and there's good cause for the exam. However, it looks to me like, based on these facts, we have Pam not producing Wynn's statement, and then immediately Dura tires files and serves the motion to compel. Now, when you file a motion to compel, you are supposed to include in it a certification that you tried in good faith to meet and confer with the other side and work out the dispute amongst yourselves instead of dragging the court in to be referee and babysitter. It's silent, but it looks like potentially Dura skipped that step. So I'm thinking that I'm, on this discovery stuff, I'm going to go through my scope, relevant, proportional, not privileged or work product. I'm going to go through then, as my did they use the proper discovery tool, those initial disclosures for the Wynn statement. I'm going to say I think it's required under number 2. And then for the physical exam, that's the tool of physical exam. I'll go through that actual, is a physical health in actual controversy and is there good cause? I'm going to say yes. And then I'm going to get to step 3 of did they use the proper procedure to try to get this information when the party wouldn't cooperate, meaning did they use the right procedure for the motion to compel? And for that, I'm going to say it doesn't look like it because it doesn't look like they tried in good faith to meet and confer first. So that's how I'm thinking to come out on those. Then we get our last paragraph. Dura tires served its initial disclosures, but did not include the advertised scientific report. Okay. Pam met and conferred. Okay. Met and conferred with Dura tires, which refused to produce its scientific report. Pam filed the motion to compel Dura tires to produce the report. So that's the appropriate procedure that you're supposed to go through for the motion to compel. They met and conferred and they tried in good faith to work it out themselves. Then Pam moved to compel. So that's the right procedure. The court granted Pam's motion, ordered Dura tires to produce a scientific report. So for that paragraph, that's going to go for me to question number 3. Did the court properly order Dura tires to produce? I'm going to talk about scope, relevant, proportional, not privileged or work product. Talk about our work product issues there. We can talk about that more in detail in a minute. Then we're going to get to, was it the right discovery tool? Again, just initial disclosures, figuring out where that fits in, if it's going to be used to support a claim that Pam's claim that Dura breached this express warranty or that it contributed to the negligent manufacturing. And then for that third step of did they use the appropriate process when the party wouldn't cooperate? Here, yes, because first they tried in good faith when they met and conferred, and then they being Pam, and then they moved to compel. Okay, so have a good general idea of where I'm going, I think, on all of this. Let's just briefly talk through each of the questions, make sure that we answer them. Okay, so number 1, did the court properly deny Dura tires' motion to dismiss? So this is that indispensable party, and we talked about this, but we need to show if we're going to say that Maurice isn't an indispensable party, we need to say that he is a necessary party. We need to say whether Joinder is feasible, and then we need to say whether if he's necessary and Joinder is not feasible, whether his participation is so vital to this lawsuit that he is going to be considered indispensable. And it looks like here the court found that he wasn't necessary, or that even if he was necessary but Joinder wasn't feasible, that he wasn't indispensable. So let's break that down a little bit. So Maurice is this mechanic. We have to decide if he is, step 1, a necessary party, meaning without him, he, P, or D will be harmed. So if we think in terms of harm to P, first we have to figure out what is Maurice's relationship to the parties here. They were vague, right? They said Maurice is a mechanic. He installed these, Dura Tire manufactures and installs. It's totally silent and unclear whether Maurice actually works for Dura Tires as an employee or independent contractor. Because of that, I'm going to march down two alternative paths. I'm going to say, look, on the one hand, if Maurice is an employee of Dura, that means that Dura would be suing on a theory of vicarious liability as the principal, as the employer for Maurice. I'm going to say, on the one hand, he could be an employee, and I'm going to march down that path for my analysis of whether he's a necessary party. And then because it's so silent and vague, I'm going to say, however, right, on the other hand, if he is not an employee, and I'll march down that path. So let's start first with if Maurice is an employee. And I'm going to say support for making that assumption, make that assumption explicit for the grader. I'm going to say if he is indeed an employee for Dura because he installed these and Dura installs, and because Pam is suing Dura for negligent installation, so arguably, they're doing that based on Maurice's installation because Maurice works for Dura. Maybe Pam's just really confused, but I'm going to use that to say it's conceivable that Maurice is Dura's employee. Now, if that's the case and she is suing Dura based on vicarious liability, I'm going to march through and I'm going to say, will plaintiff be harmed? Will Pam be harmed if we don't join Maurice? And the answer for that is no. If you have a vicarious liability situation, that means that the employer that you are suing is jointly and severally liable with the actual tortfeasor, which means that plaintiff can recover the entire amount of damages from either the principal or the agent. And then they can seek indemnity or contribution, right? If she's just suing that principal, the principal can then turn around and seek indemnity or contribution from that agent. So that is the situation that we have here if Maurice is an employee of Dura, which means that even if Maurice is the actual one who did the negligent installation, Pam can still recover the entire amount from Dura, meaning she is not going to be harmed at all by not including Maurice. So that's going to be a no harm to P situation. So then we have to figure out if D will be harmed. Now, what we mean by that for purposes of this necessary and indispensable party is, will D be subject to multiple or inconsistent obligations if we don't join Maurice? So typically what that looks like is if I sue Joe because I'm claiming that Joe has a pen that belongs to me. This is my special pen and Joe has it and I want it. And the court finds for me and orders him to give me the pen. But somebody else who was absent from my lawsuit also sues Joe separately and says, hey, that's my pen. And the court in that case says, yeah, Joe, give that pen to that person. Now Joe is subject to inconsistent obligations. One court said give it to Emily, one court said give it to the other person. That's what we're talking about with these inconsistent obligations. We don't have that kind of situation here. So if, if Pam only sues Dura and doesn't sue Maurice here, we have a situation where Dura might have to pay the whole thing, but they're not going to be subject to multiple or inconsistent obligations, and they're not actually going to be harmed because they can just turn around later and sue Maurice for indemnity or contribution. Alternatively, right now, instead of waiting, they could implead Maurice under Rule 14. It's a federal impleader rule. They could bring him in as a third-party defendant on the basis of this vicarious liability indemnity or contribution theory, right? And courts have actually explicitly held, you don't need to know that for this to get the right answer in this fact pattern, but courts have held that in that situation where you have a potential indemnitor or contributor, they're not a necessary party because the defendant is able to just implead them if they want to. And so because of those reasons, we don't have a harm to D situation for necessary party. And then the third thing to consider is if there is harm to Maurice, the absentee, if he's not joined. And if Maurice is not joined in this action, he's just not going to owe Pam any money in this action, so no harm. It's true that Dura could then sue him later for indemnity or contribution, but Maurice will get to assert his defense then, so he hasn't been harmed in any way, right? He'll just get to assert his defense later. Or if Pam loses against Dura, then she may wind up suing Maurice separately later and saying, you negligently installed, and again, he can just defend himself there. And in fact, he'll be able to use issue preclusion in that case, right? And say, look, you already sued Dura on the basis of me doing negligent installation. The jury there said no. You had a full and fair opportunity to present your case on that. And so then Maurice can just go ahead and say, so you don't get to relitigate that. I didn't do it. No negligent installation. So in any event, Maurice is not going to be harmed either. We don't have a necessary party if Maurice is an employee. If, on the other hand, Maurice is an independent contractor, and they haven't given us any facts about this, right? We don't have any facts about the factors to decide if he's an independent contractor versus an employee. So I'm not going to give those rules. I'm not going to get into them on this essay. They just haven't given me any facts to apply those rules to. But I will just briefly mention, if he's an independent contractor, then ordinarily there's not going to be any vicarious liability from Dura for him if he's an independent contractor, with a couple potential exceptions. Say, conceivably, maybe this is a non-delegable duty, installing the tires. It's a safety issue, probably not, but I could throw that in there. Or potentially more likely, if Dura held Maurice out with apparent authority and represented to these third parties, made it look like Maurice was their employee, then they'll be vicariously liable for him. So if they had Maurice installing tires, wearing a shirt that said, Dura tires, and he was doing it at their installation site or right next door or something like that, then they could be vicariously liable for him. Otherwise, generally speaking, not going to be vicariously liable for the independent contractor. So if we have a situation where where Dura is not vicariously liable because he's an independent contractor and those exceptions don't apply, or if Maurice is just some unaffiliated mechanic, right? Pam just took these tires to some unaffiliated independent mechanic. Then we have a different scenario where we're going to look at our harm and we're going to say, well, is there going to be harm to PD or Maurice if he's not related to, right, affiliated with Dura in this way? And for that, I would say, well, potentially they're joint tortfeasors. Right? If Maurice's negligent installation combined with Dura's negligent manufacture to cause plaintiff some indivisible harm, then they're joint tortfeasors, and joint and several liability applies, and we're in the same situation that we were above, where plaintiff's not going to be harmed because she can recover the entire amount from Dura as a joint tortfeasor, who can then later turn around and get indemnity or contribution from Maurice, or can implead him now. And for that reason, there's not going to be harm to defendant either. And Maurice is not going to suffer any harm either. Same analysis that we did above when we talked about vicarious liability. If Pam or Dura sue him later, he can just assert his defenses then. So either way, Maurice is not going to be a necessary party. Now, if you're confident in that, you can stop there. If you're not sure, then you want to do CYA and not cut off your ability to get points in case you're wrong, and you want to keep going. However, in the event that he is a necessary party, and keep going. So step 2 is going to be feasibility, right? And if you concluded differently, if you said he is a necessary party, then you're definitely going to this step. And that's asking if it is feasible to join Maurice, meaning there's personal jurisdiction, subject matter jurisdiction, and venue over him. Now, in a fact pattern like this, I would go very quickly over that because they haven't given you any facts about this. They haven't told us where Maurice is domiciled, where he's a citizen, so we don't know if there's complete diversity for subject matter jurisdiction. We don't know if there's going to be personal jurisdiction over him because we don't know if there's general jurisdiction because he's being sued in his domicile, or if this is specific jurisdiction because he's being sued where the install occurred. We don't know where he did the install. We don't know where he's being sued. So we don't have facts to tell us about subject matter jurisdiction, personal jurisdiction, venue. I would get through it very quickly and just show the grader, right? If it's, if he is being sued, where he did the install, then there's specific personal. If he's being sued in his domicile, then there's personal, things like that. Then there's general personal. Okay, so that's step 2. And then step 3, I would also get through quickly because there aren't really facts to do this and because he isn't a necessary party. That's where the court has discretion to say, look, in the event that he is a necessary party and joinder is not feasible, can we proceed anyway? Or do we need to label him an indispensable party and stop the suit? And those factors that the court looks at are whether plaintiff, defendant, and absentee Maurice would actually suffer prejudice, right? How much would they suffer if they proceed without Maurice? The answer here is really none. The second factor is if there is prejudice that he would suffer, can the court reduce that prejudice by, doing things like if it's some pot of limited funds, setting some aside for the absentee? Not really at issue here. And then that third factor is, will a judgment without Maurice be adequate? Yeah, if we're on a theory of joint tortfeasor or vicarious liability, Pam can recover the entire amount from Dura, so totally adequate. And then the final factor is whether if the court were to dismiss this case by labeling Maurice indispensable, is there some adequate alternative forum where plaintiff could refile where she's able to sue both of them? And again, we don't have facts for that. Okay, so that's it for question 1. Then we move on to question 2 about whether the court properly granted Dura's motions to compel. And so we've already talked pretty much about all of this, but let's just go over real briefly. Anytime we have that discovery, we're looking at, discovery issue. 1, scope of discovery. Is this relevant, proportional, and not work product or privileged? 2, are they using the appropriate discovery tool? And 3, if this is proper discovery and they're seeking it properly, but the other party is not complying, are they using the appropriate means, right? That motion to compel, are they going through the right process to get it? And so if we're starting with that win statement, we're saying, yeah, even if it's that inadmissible hearsay, doesn't matter as long as it is relevant to a claim or defense. And here it says it's favorable to Pam's case, so that's going to be relevant to her claim. Even if it winds up being inadmissible hearsay, who cares? It's still relevant for discovery purposes. Proportional to the needs of the case in federal court. What we look at there, you write about whichever factors you happen to remember, things like the importance of the issues that are at stake in the action, the amount of controversy. We don't know what the amount of controversy is here. It's got to be over 75K because it's a diversity case and they told us that there's jurisdiction, but beyond that, we don't know. The party's relative access to the relevant information. So here, that kind of cuts both ways. So Pam is in exclusive possession of Wynn's statement that she gathered. So she has access to that, but Dura could probably go ahead and do their own interview of Wynn and get the same information. The fourth factor is the party's resources. We don't know. We don't have any facts on that. Fifth is the importance of the discovery to resolving the issues in the case. This is potentially important, right? Wynn's statement, to the extent that we're looking at Wynn's statement, it could be helpful to decide, right? This warranty was if you drive properly, then the tire won't go flat. Maybe Wynn's statement is going to help Pam, since it's favorable to her case, show that she drove properly. That seems pretty useful, pretty important to resolve that issue. And then finally, the burden, we look at whether the burden or expense of producing that discovery outweighs the likely benefit of the discovery. And here it seems like it would be an extremely low burden for Pam to just hand over Wynn's statement. So all of that is going to weigh in favor of saying, yeah, it's relevant. And then not privileged or work product, not an issue for this one, right? It was gathered by Pam, not her attorney, so no work product issue, no privilege issues. So that's our, is it within the scope of permissible discovery? Yes. Next, we're asking if she's using the appropriate procedure to get it. And that's our initial disclosures that we already talked about. Falls into that second category of that document. And so, yeah, she has to disclose it. And then finally, we're going with our third step of, is she using the appropriate procedure when the other party's not complying? And that's that meet and confer problem is what it looks like we have here. It looks like there was no good faith meet and confer, so didn't properly pursue the steps of a motion to compel. And then for that physical exam, we do that scope, relevant, proportional, not privilege or work product. Again, so if she's claiming an NIED near miss situation where she has to show physical manifestation of her distress, then we would get that physical exam seeking something that is properly within the scope of discovery. It's relevant because it would be an issue for that physical manifestation theory. If she's not doing that NIED theory, then all we have here is property damage and emotional distress and no physical injury, then that would be beyond the scope. It wouldn't be relevant to a claim or defense. Proportional to the needs of the case. You can go through those same factors again. This is intrusive, right? The burden of getting a physical exam is higher than just producing a statement. But if she's bringing the claim for NIED with that near mystery, she's putting it at issue. And so if that's the case, then I'd say it's proportional. And then not privileged or work product, it doesn't seem to be any issue there. Potentially, you could argue, oh, well, there is doctor-patient privilege. That's a thing that exists. Not in federal court, but this is a diversity case under Erie. Privilege is going to be substantive. We're going to use the substantive privilege law of the courthouse where the case is brought. If it's California or some other jurisdiction that recognizes doctor-patient privilege, then there is such a privilege. But by putting her physical health at issue, by bringing the suit, again, assuming she's doing that physical manifestation near miss theory, then she is waiving that privilege. Okay, so that's where I would go with that. Then so that's gonna say, yes, it's within the scope. Second step is a proper tool being used, and that's the initial disclosure, that's the physical exam, right? That's the tool that she's trying to use, is get a physical exam. And that's what we already talked about. In federal court, you need a court order. You have to show that the physical health is in actual controversy and good cause. And again, if it's that NIED near miss theory, the physical manifestation, I think we can make that argument there. Okay, and then finally, that procedure, is she properly doing, or is Dura properly doing that motion to compel? Looks like they skipped the meet and confer step. Okay, so that's what I would do with question 2. And then question 3, finally, almost done, is what is it? Oh, did the court properly order Dura to produce its scientific report? So again, I would start with that same scope, relevant, proportional, and then not work product or privilege, recognizing that's where we're going to spend most of our time. So relevant. Is this report relevant? Well, to the extent that it contains an express warranty, then sure, it seems relevant to a claim for breach of that express warranty. She's also alleging negligent installation, manufacture. If there is some research on these flat tire incidents right in this report that maybe shows that there's a lot of flat tires going on with this special coating on their tires, maybe you're going to argue that an RPP manufacturer would change the formula for the coating and that it wasn't reasonable for them to keep manufacturing the tires in this way. And so that's going to help you find your breach for your negligent manufacturing theory. It's another way to argue that it's relevant. So yes, I would say satisfies the idea for relevant. Satisfies that relevant to a claim or defense. Second step, proportional. Again, you can go through those factors. Arguably pretty important if we're saying that this is the basis of this express warranty claim and maybe that breach of negligence, et cetera, et cetera. And the burden for this one is low because presumably they already just have the report and all they have to do is hand it over. And then finally, not privileged or work product. So probably, don't know this, don't need to know it, but courts have held that even in a diversity case in federal court, we're going to use federal work product rules. So we're going to use our federal work product stuff. Think about this in 3 steps. 1, is it work product? 2, if it is it discoverable anyway? And then 3, are we going to redact anything? So is it work product? That's those materials prepared by an attorney or for an attorney in federal court in anticipation of litigation. And again, we talked about this already, but that's, I think, the unclear part here. Research on flat tire incidents. If this was prepared in anticipation of future claims of breach of this express warranty, then that would count as an anticipation of litigation. If it was just prepared to decide where to set the warranty, at 7,000 or for some other reason, then that wouldn't be satisfied and it wouldn't be work product at all. Assuming that it is work product, since it's in the gray here, I would definitely go on to step 2. Say, is it discoverable anyway? And in federal court, the answer is no, unless the other side, the one seeking it, shows substantial need and that it's not otherwise available. So if our theory is that plaintiff would not have, or if the theory is that Dura would not have, a reasonable person in Dura's position would not have continued manufacturing these tires in this way, having this information, right? If they found out that there's so many flat tires, a reasonable person would change it, then I think you would say there's substantial need for this and it's not otherwise available because we're basing the claim on that report and we need to produce it. So I think you can argue that way for step 2. And then step 3, if you're saying, yeah, it is work product, if it was prepared in anticipation of litigation, and there's substantial need, it's not otherwise available because the whole basis for this negligence claim is that an RPP who had this report would have changed what they were doing and Dura didn't change what they were doing. Then you get to, okay, step 3, it's going to be discoverable, but we always get to redact the lawyer's mental impressions, opinions, conclusions, and legal theories. Probably not any of those in a scientific report, I would think, but you never know. So you can just mention that we'd redact those anyway. So I'd go through that. And then, after that, scope of discovery, you're asking if they're doing the proper procedure for that. And again, this is the initial disclosure. So you have to decide if it fits into one of those categories. I would again go to category 2 of documents that are supporting a claim or defense. And say it's one of those, and then did they go through the appropriate process to do that? And here, Pam did meet and confer before moving to compel. So in this case, that is the proper process. And that's what I would do there. There's probably some other stuff in this essay, but I think that should be plenty to pass. So there you go.